All right. State versus Edward Ferris, 21 CR 95. This is a hearing being conducted by Zoom. Mr. Ferris is appearing from the Justice Center. His attorney, Catherine Hapner, there she is. We've got so many squares up there, it looks like Hollywood squares. So Ms. Hapner is appearing from her office, and then appearing on behalf of the state is Prosecutor Collins. The defendant was convicted of retaliation and was placed on community control on, let's see here. September 1st of 2021. There has been a notification filed by the probation department alleging that the defendant has violated the terms of his conditions, and that was, looking for that, notification was filed on April the 8th, and it alleged that he had violated the supplemental entry filed on October 10th of 2023, and that he had failed to complete the Genesis program as directed. It alleges that he left against staff advice on October 19, 2023. And a capias was issued back at that time, and it looks like he was arrested on that capias on April the 7th. The court notified Mr. Ferris of the alleged violation and appointed Ms. Hapner to represent him, and the matter is before the court now for hearing. Now, Ms. Hapner, are you and your client both in agreement this matter can be conducted by Zoom rather than a in-person courtroom appearance?
We are.
And you're all right with that, Mr. Ferris?
Yes, sir, Your Honor.
All right. Now, Ms. Hapner, have you had an opportunity to consult with your client regarding the allegation?
I have, Your Honor, and he will admit that he did leave Genesis without prior permission.
All right. Now, Mr. Ferris, you do have a right to have a hearing on this matter in which the prosecutor would have to present testimony that proves that you have done this violation. You have a right to have your attorney ask questions of any witnesses the state presents, called cross-examination. You have a right to present testimony on your own behalf as well. You're not required to, but you may. Now, in the event that it's found that you have failed to comply, one of three things can happen. I could continue your community control under the same conditions previously ordered. I could continue it with additional conditions that I think are appropriate. Or the third and the most serious is that I could terminate your community control and sentence you to a period of between 9 and 36 months in prison. You understand that?
Yes, sir, Your Honor.
All right. And has anyone promised you anything or threatened you in any way to get you to make this admission?
I can't hear you. What did you say?
Has anyone promised you anything or threatened you in any way to make you admit to these violations?
No, sir, Your Honor.
All right. Then do you admit to the violation that was filed on April the 8th that I just read to you a moment ago?
Yes, sir, Your Honor.
All right. All right. What's the position of the state and the probation department? I do see there's a letter here from Brighter Days. I don't know who that is, but I haven't had a chance to review it. I just saw that we have that dated yesterday. Ms. Collins?
First, Your Honor, we did leave a message for the victim in this matter to let them know.
Oh, I'm sorry. Thank you.
Place.
Yeah, thank you for that. Okay.
I'm not for sure what Mr. Balzer's position is. I know that typically at this point, I think that the state would ask for the defendant to be sentenced to prison. However, I think that Mr. Balzer is hoping that he can have an impact on Mr. Ferris and maybe have a positive impact on him to get him to realize how serious what he's doing is. maybe Mr. Balzer has more to add to that.
Mr. Balzer?
Yes, sir. He stayed about a week at Genesis, after I told him this was probably the last chance, like he has to do this. Once he left there, he put himself into brighter days. We did not receive any information on that until about the first of the year. I spoke to Eddie then and told him that he had a capias. He needed to turn himself in and take care of this, and we'd go from there with it. He kind of messed around. He stayed in treatment, but he did not turn himself in until April of this year. And here we are today. But he is receiving treatment, just not what you ordered, Your Honor.
What is the Brighter Days? I'm not familiar with that. Where is it located?
I believe Chesapeake, Ohio.
All right. And this is he was receiving substance use disorder treatment. Is that what he was receiving?
And mental health.
And mental health. Okay.
I don't know that it's comparable to Genesis, certainly not Star, which is what he was needing. But the letter does state that he's doing well there. So.
Right. It does. I see that. All right. All right, Ms. Hapner.
Thank you, Your Honor. I discussed this with Mr. Ferris and indicated to him that there may not have been an issue with him going to Brighter Days, but he needed to get that approval before leaving Genesis. And I think he understands that now. So that's the downside. The upside is he didn't just leave Genesis and just wander around. He did get himself into the Brighter Days treatment facility. I've also called Brighter Days and spoken with his counselor there, and they've indicated to me the same thing they indicated in your letter, the letter that you received, that he's doing well there. It is clear to me that Edward he doesn't have family support. He doesn't have the support system that some of us have. And while that's not an excuse, I think it goes maybe to explain he relies on himself, and so he wasn't accustomed to having to check with other people, and he is trying, I think, to get clean by putting himself into the treatment facility. So we would ask that you take that into consideration and continue his community control.
All right, Mr. Ferris, anything you would like to say?
I just want to say a couple of things. I just want to tell you I'm sorry for leaving Genesis, and I made mistakes, and I violated them 3 times on my community control. And I mean, I prayed every day if I could go back to Brighter Days and complete this program for you. And I wanted to stay clean this time. I haven't prayed to stay clean. I just want to have one small chance if I can get back, but one small chance, Your Honor. And I'm sorry, I'm sorry, Your Honor. I'm really sorry for everything I did. And Brighter Days has helped me get my birth certificate. I'm in the process of getting my ID and everything to get me a job. And I was wanting to pay my fines and everything and do the right thing this time. And I just want to let you know I'm sorry. I'm really sorry, Your Honor.
Okay. Well, Mr. Ferris, a couple things about what you said. Number one, if I understood you correct, you said you wanted to complete this program for me. This program isn't for me. I'm not the one with the problem. You are. And so if you're not in it to help yourself, then you're probably wasting your time and my time and everyone else's time. It's got to be about you. It isn't about me. It's about you. Second thing, you've had 3 chances already. Okay? This will be the 4th chance. Now, I'm not known for that. The one thing that, though, that is weighing in your favor here, and it won't happen again for you, is the fact that when you did leave, you went into treatment and you've been there, according to the counselor, since November the 1st. That part was good. The bad part is you need to call. You should have been reporting. You still had to report. And we needed to have proof that you were testing clean. Now, they say you have, except for one issue with marijuana, I think. And keep in contact. Because, we don't know how you're doing. We didn't even know where you were. And then once he found out, Mr. Bolster, I think, was extremely patient and waited longer than he probably should have before he filed the request for the capias. And so, you've been given an awful lot of chances here. And so one of the things I'm doing here is I've written on this page right here in front of me, these are notes that go into the file about this hearing, and it says right there at the bottom, last chance. This is the last chance you get. The next time you come in here, I don't care if, the courtroom is 12 inches deep in your tears. You're gonna go to prison if you violate again. So it's the order of the court that your community control be continued under the additional conditions as follows. I don't know if we have already or not, but I'm extending it to 5 years. You are to successfully complete the Brighter Days residential treatment program and any aftercare they recommended. And you're to comply with all the other original conditions, which includes reporting and asking permission to change your residence, keeping them informed of your residence and your place of employment. You need to do all the things that you were originally ordered to do and pay the court cost.
Yes, sir.
All right, so you will be released today. You report to the probation department upon your release before 4 o'clock. If you don't get there before 4, you got to come back before noon tomorrow. All right, you understand? All right, thank you.
Thank you, Your Honor.
All right, could we have Zachary McGraw, please? All right, this is case number 22 CR 237, State of Ohio versus Zachary Thomas McGraw. And are you Zachary Thomas McGraw appearing there from the jail?
Yes, sir.
All right. Mr. McGraw's attorney is Catherine Hapner. She's appearing from her office. This hearing is being conducted by Zoom. And appearing on behalf of the state is Prosecuting Attorney Collins. The defendant was originally placed or granted intervention in lieu of conviction on the charge of aggravated possession of methamphetamine, a 5th-degree felony. And that occurred back on August 24th of 2023. There was a notification filed and a motion to terminate by the state on March the 18th, and the matter was set for a hearing on that, and the defendant failed to appear. And so a capias was issued for his arrest on April the 11th, and then he was taken into custody and was informed of the notification. And it says here in the motion, in the entry, Ms. Hapner, that you were employed. Is that correct?
No, Your Honor, I was appointed.
Okay, all right. Because it says in the entry notification that was done while I was out. So.
I noticed that too and thought it odd, but it was an appointment.
Okay. Well, I don't know if we have an entry here, so I'll make a note to. I don't think we have a financial affidavit. So, Mr. McGraw, you'll need to fill out a financial affidavit, and then I'll appoint Ms. Hapner retroactive to the date of the notification, which was April 17th. All right. Now, Ms. Hapner, you had a chance to review the allegations with your client.
I have, Your Honor. I have discussed it with him, and he admits that the allegations are correct.
All right. Just to review these for you, Mr. McGraw, the allegation that the allegations are that you violated the order filed on August 24th of last year. Rule 3, you have failed to comply with your treatment plan through Recovery Council. That you were closed out unsuccessfully on February 12. Your last attendance was November 21 of last year. Rule 4, you failed to report since November 22, 23. Failed to respond to voicemails and a letter sent to your last known address. Rule 10, You were put in the call-in drug testing program, and on November 21st, you only called in a total of 3 times as being put there into that category, and the last test you had done was November 22nd. Rule 11 is that you had tested positive for amphetamines and methamphetamines on September 25, November 23, positive for THC on October 19, November 7, and November 21, 23. Rule 14, you haven't made any payments on your financial obligations, and you owe the court $401 and probation fees of $300. And then Rule 15, that you had failed to comply with your treatment plan. So those were the allegations, Mr. McGraw, and you understand those allegations?
Yes, sir.
You understand you have a right to have a hearing?
Yes, sir.
You have a right to, and you understand that the state would have to prove these allegations, and if they do, then the consequence of that is that your previous plea of guilty that was filed but not accepted will be accepted, and there'll be an entry of finding you guilty, and then there will be a sentencing hearing. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened you in any way to get you to do this?
No, sir.
All right. You have any questions about the allegations or the proceedings here?
No, sir.
All right, then do you admit the allegation?
Yes, sir.
All right. All right, then the court will find the defendant guilty. And again, we'll appoint Ms. Hapner to represent him once, and an officer there will get you a financial disclosure form and fax it up to us, and then we'll put her appointment on. And I'm going to order updated pre-sentence report, and particularly interested in if there might be either STAR or a residential placement.
I believe he is scheduled for the Recovery Council for next Monday, May the 6th.
Okay. Well, we still have to do a sentencing.
Sure.
So that's the recommendation of the probation department, Ms. Arjima? Or I guess Ms. Sturgill's there too?
Yes.
Okay.
She advised we have it is a bad day for the recovery council.
And it's May 6th?
Yes, sir.
All right. All right, well then, I'll order the updated pre-sentence report. The defendant will be held until May the 6th, at which time he'll be released on his own recognizance to the Recovery Council. Now, Mr. McGraw, it's the term of your bond. Your OR bond is that if you fail to appear, you could be prosecuted for an additional felony. And if convicted, could be sentenced, no matter what happens in this case, to prison. So if I release you, you're going to go there. But if you decide you don't want to stay there because it's not a lockdown facility, those people can't stop you from leaving. But if you decide to leave, you have to report back to the jail. If you don't, you have violated your bond conditions because the OR is solely on the condition that you go to treatment. Now, the other thing is if you take off and don't go to treatment and stay in treatment, then there's a pretty good chance that you're not going to like the outcome. It's probably going to mean doing a long stretch of up to 12 months in custody. Okay, you understand?
Yes, sir.
All right. So the disposition then, or sentencing, I should say, will be set for May the 16th at 1 p.m. And if you're at the Recovery Council, that can be by Zoom. If you leave the recovery and you don't come back to jail and you don't show up for that hearing, that will be an OR violation, then you'll be subject to being prosecuted. You understand?
Yes, sir.
All right. Anything further from counsel?
No, Your Honor.
All right.
No, Your Honor.
All right, thank you. All right, case number 21-CR57, State of Ohio versus George Dotsire. And you're George Dotsire. there at the jail?
Yes, sir.
All right. Mr. Dossar was indicted back on April the 6th of 21, 2 counts of illegal use of minor in a nudity-oriented performance, 53 felonies. He was arraigned, I believe, day before yesterday, and, the 30th, and the court set bond at $10,000 and appointed Danielle Witt to represent him. She's on vacation, and the statute requires there be a bond review within 48 hours, so Ms. Hatner has graciously accepted to stand in for Ms. Witt. Now again, Ms. Hatner, I know that neither you nor Ms. Witt probably have any information, but if you'd like to make any statement on the bond, I'll hear it.
You're correct. I don't have any information. Obviously, Ms. Witt didn't even know about it. I'm not aware that he has any prior felonies or failures to appear. These are low-level felonies, and while I understand the nature of them is not pretty, they are low-level. We would ask that he be granted a no-R bond.
All right, Ms. Collins?
Actually, I'm not aware of any felony convictions either. And I would let the court know that these are photos. They're not something that he made or children in his home or something like that. These are photos that were taken
Downloaded from the web? Okay.
Yes,
All right.
from an internet chat.
Okay. All right. Well, the one thing concerns me at this point is that it took 3 years to find him, and at this point, I'm going to leave it at the same, but once Ms. Witt gets back from vacation and talks with you, Mr. Dossar, if there's additional information that can be brought to the court's attention, the court will consider it. I will also note to both counsel, I have here a message from Mrs. Hoyer with a copy, apparently, that Mr. Dossar's, I guess, former girlfriend has indicated that he cannot live at that address at Sharpsville Road as listed in his financial disclosure form of what I put in the arraignment entry. And she apparently emailed Ms. Hoyer, or dropped it off, I don't know which, a copy of a notice to leave the premises. And so if you do get released, Mr. Dossar, you're going to have a place to go to, so that's something you'll need to work on to tell your attorney when she's able to talk with you. Because,
I do have a place to go to.
all right, what would that address be?
I'm not really sure. I know it's my brother's girlfriend's house down on 131.
Well, until we find that out, I'll just leave that blank. I'm going to scratch out the old one. That'll be some of the information you'll need to give to Miss Witt once she's able to talk with you. I assume she'll be back next week, Miss.
Yes, she'll be back Monday. I think she has a fairly heavy schedule Monday, but she'll be back then.
All right, so she will get in touch with you sometime next week. She will have to catch up from what she's been off on, but she'll get in touch with you. Okay? Thank you. Case number 24 CR 47, State of Ohio versus Tiffany L. Watson Bathing House. This is a pretrial being conducted by Zoom. Representing the state is Prosecuting Attorney King. Representing the defendant is William Parker. Is your client there in the room now, Mr. Watson or Mr. Parker?
Your Honor, she's actually at the probation office.
Oh, okay, there she is. All right, sorry.
And representing the state is Prosecutor Collins.
Yes, that's true. What did I say?
King.
Okay. Well, you know, as a lawyer, you know that our mouths run independently of our brains often, so that was what was going on there. Okay. You're Tiffany Watson Bathing House, appearing there from the probation department?
Yes, Your Honor.
All right. Okay, so this is a pretrial, and the defendant is charged, it looks like, in counts 2 through 5, 2 counts of disseminating matter harmful to juveniles, and 2 counts of endangering children. The courts note that Mr. Parker had filed a response to discovery yesterday by fax. The court received it. Did you get a copy, Ms. Collins?
Yes, Your Honor, he
Okay.
emailed it to us.
All right. And there are no pretrial motions, are there, Mr. Parker?
No, Your Honor.
Okay.
And in fact, Your Honor, Ms. Collins and I, along with Mr. King, had a conversation yesterday, and a plea offer has been extended. I reviewed that with my client, and she wishes to accept, so I would like to set the matter for a change of plea hearing.
Oh, okay. Let me see if I can get the calendar, and we'll do it right now. I had a trial scheduled for next week. I think I have some time either Monday or Tuesday. Wednesday, I've got some other plans.
Your Honor, I could do Tuesday afternoon.
All right.
Actually, Your Honor, I apologize. I'm actually out of town Tuesday afternoon, so let me look at that again.
Could you do Monday?
I'm actually in Claremont County on 3 cases that afternoon, Your Honor. I apologize.
Well, what about in the morning?
In the morning, I'm in Hamilton County. I apologize, Your Honor.
That's all right.
Supposed to plead tomorrow.
All right, we have Thursday available anytime.
I could do the afternoon on Thursday, Your Honor.
Okay, 1 o'clock Thursday. That would be May the 9th. So, Miss, and we can do that. You want to do it by Zoom, or you want to come in court at the courthouse?
Your Honor, just for plea hearing, it's kind of my personal preference to do it in person in case
That's fine.
anyone has any questions of me, so I'd
Yeah.
like to do it.
Well, usually with people out of town, a lot of times I like to do Zoom, but that's fine. We'll do it in person then.
Thank
All right,
you, Judge.
at 1 o'clock. So you'll need to be here at the courthouse, Miss. You go by Watson Baden House or Baden House or?
Watson.
Okay, but you'll need to be here then at 1 o'clock next Thursday, the 9th. All right.
Yes, sir.
Okay. Thank you.
Thank you, Your Honor.
So, Felina Harrison, is she there at the probation department?
She is, Your Honor.
Okay.
She's on the probation department.
You're right.
You say she is? All right, this is case number 24 CR 22, State of Ohio versus Felina Harrison. You're Felina Harrison, appearing there from the probation department?
Yes.
All right. This is a Zoom hearing. Ms. Harrison is represented by Sarah Barger, who's appearing by Zoom from her office. Appearing on behalf of the state is Prosecutor Collins. Now, Ms. Barger, this is set for a plea for intervention. Are you and your client both in agreement that this matter can be conducted by Zoom rather than in-person hearing?
Yes, Your Honor.
Yes.
Are you all right with that, Ms. Barger? I'm sorry, with Ms. Harrison?
Yes. Yes.
All right. If you have any questions you need to ask Ms. Barger, or you have anything you'd like to speak with her during the hearing, just tell me and I can put the two of you in a breakout room. It'll just be you and her on the screen. No one else will be able to see you or hear you, okay? All right. Now, The defendant filed I believe, filed a motion for intervention and did file the stipulated questions on April the 24th. And the court ordered an assessment and a pre-hearing report from probation, which I did receive, and also have a letter stating that she is in a treatment program at the Recovery Council. And then also, I think, also St. Paint Valley Mental Health. Is that correct, Ms. Harrison?
Yes, I was inside of Pink, but it became too much of a hassle because it was a courthouse. So I told my probation officer, I said, I can't get in a consistent basis inside of Pink Mental Health. So I told him, I was like, a lot of people said Recovery Council was good. And so I went there and he said, that's why you made that decision, because I was going to say something.
Okay. Well, actually, I'm looking here. I didn't realize this is from August the 25th of last year. So, and it was addressed to the Highland County, it says municipal court, it's county court. So that's actually out of date. I don't know how it ended up in a probation file, but it's there. But I do have the one from the Recovery Council, and you're set to start next Monday, correct?
Yes.
All right.
Yes.
All right. So, Ms. Harrison, I have a proposed plea agreement here, and I'm going to show you the first page. It says a plea of guilty and entry granting intervention in lieu of conviction and staying criminal proceedings. Has your name and case number on it. I'm going to hold that up to the camera. And do you recognize that document?
Yes.
All right. And then on page 3, there is a sentence about a third of the way down that reads, enter this plea voluntarily. And right below that appears to be the signature for Lena Harrison, 4/24/24. And is that your signature?
That is my signature.
And that's the date you signed it?
Yes.
All right, now, you're charged with a felony of the 5th degree. And normally, if someone is convicted of a felony or any other charge in this court, then there's a sentencing. And that can be, in this case, 6 to 12 months in prison, a fine of $2,500, and a license suspension of 6 months to 5 years. Or it could be community control, which is probation, which is up to 5 years. And if that happens and the court sentences you to one of those things or a combination, then you are convicted and you have a felony record. Now, there's a procedure that's available under the law for people with very minimal records that if either alcohol or some sort of improper use of drugs or mental health was a contributing factor to the commission of the offense, then if a person pleads guilty but has been accepted into a certified treatment program, which Recovery Council is, and they comply with that treatment plan, one of which conditions must be that you abstain from the unlawful use of substances and alcohol for a period of at least a year. Now, under the law, I can put you under this program for up to 5 years. I normally do 2 years because I think that's sufficient time to determine whether a person is going to be successful in changing their life. And you are put under supervision conditions that are much less stringent than the usual conditions for somebody who's been convicted. Now, the advantage for you is that if you are successful with the program, once the court receives that notice from the probation department, your case is dismissed. Because even though you entered a plea of guilty, when we put you into intervention, I don't find you guilty. And that's what's required in order to have a conviction. And when somebody pleads guilty, they're still not convicted until their conviction has been completed by the court finding them guilty and sentencing them. And with the way it works in this program is you plead guilty, but I don't find you guilty. I stay the proceedings, which basically is putting them on an inactive basis to await the report from the probation department. And if you successfully complete the program and you comply with all of the conditions and you pay the court costs, then the case is dismissed and the court will set it for a sealing hearing, and unless something happens in that window of time, the court will seal your conviction, and then it'll be removed from the, or seal your charge, I should say, not your conviction, seal the charge, and it will be removed from the public record. So that's the advantage to you. The disadvantage is that it's your last chance to stand on a plea of not guilty and defend the charge. So if you decide that you want to defend against the charge, then you don't want to do this. But if you do it and you're not successful, you can't come back then and say, okay, now let's have a trial, judge, because this is your last chance. So that's the disadvantage. You understand that?
Yes, I do.
Okay, and you've discussed that with your attorney.
Yes,
All right, and she went over this form with you before you signed it and explained everything in the form?
yes, from beginning to end, yes.
All right, and it's been about 8 days since you signed it. Is this still what you want to do?
Yes,
And you entered into this agreement voluntarily,
yes,
and you're proceeding voluntarily today?
yes,
All right. Now, as I said, this I've told you what the penalties are, and you understand that, correct?
yes.
All right. Now, if you're put into this program and you do not successfully complete it, in order for that to happen, probation department has to file a written notice with the court and give you a copy that says the defendant's not complying with these conditions, set forth what they are. Then we have a hearing. That hearing, you are represented by counsel, whether you can afford it or not. If you can't afford it, the court appoints one for you. And then you have the right to contest those charges, and so the state has to prove those. If they prove it, then at that time the court finds you guilty and then proceeds with the sentencing. And that doesn't mean that you would go to prison. You still have the same options as before. Possible prison term of 6 to 12 months, fine of $2,500, license suspension of 6 months to 5 years, or probation. Probation is similar to the intervention program, but it is more restrictive and there are more conditions because now you are a convicted felon, whereas before you were not. And so in that situation, then you would have to comply with those conditions, and that could be for a period of up to 5 years. And it works the same way in terms of if you're alleged not to have complied, the same process works. They file a written notice, you get a copy, you have a hearing, you're entitled to have an attorney, and one will be appointed if you can't afford to hire one. And at that time, if there is a finding that you failed to comply, then you can be sentenced to 6 to 12 months and fined $10,000 and have a license suspension of 6 months to 5 years. Should that happen, the law provides that the adult parole authority, if you go to prison, could put you under post-release control supervision for a period of up to 2 years, and if they do, you'll be supervised under the conditions they set. And if during that period of time they find that you have not complied, then they could return you to prison to make you serve an additional period of up to half of the prison term that was imposed by the judge for one or more violations. But if you commit a new felony while you're under that supervision, then the judge in the new felony case could sentence you for committing that offense while under post-release control, in this case, to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively the sentence in the new case. You understand that?
Yes,
All right. Now, the charge alleges that on or about July 26, 2023 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, and that's a new one on me, methylphenidate, in violation of Section 2925.11. So that's the charge. Now, do you understand what the state said you did, when, where, how they alleged you did it?
yes,
And you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, and possible offense you might raise at trial with your attorney.
yes,
And are you satisfied with her advice and competence in this matter?
yes, I am.
Are you under the influence of any types of drugs or alcohol at this time?
No,
Now, on page 2, it indicates you're going to plead guilty and the state's recommending intervention. And it's the court's intent to grant that. But is there, has anyone promised you anything other than that to get you to plead guilty?
no,
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
I got a CDL Class A.
Okay. That would go into your driving record, so a conviction for a felony could result in the license being revoked, but that's not something the court does. But we're required to report that. You understand that?
Yes.
Okay. Now, you have constitutional rights, as I indicated to you before I can accept this plea. You have to understand them, because again, this is your last chance to stand on a not guilty plea. And so that includes the right to counsel, and I do appoint Ms. Barger to represent you because you were not able to hire your own attorney. And that wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you'd like to provide. So if you decide you don't want to do this, she'll continue to defend you and represent you throughout the hearing and or the proceeding, including a trial if that's what you want. You understand that?
Yes.
Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, those 12 are selected, the evidence would be presented, then they'd be instructed on the law by the judge, and then that jury would have to decide by a unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and in that case, you would have what's called a court or bench trial, meaning that instead of the jury, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. You understand that?
Yes.
Now, under the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you and your attorney, and anyone else may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that would be to try to bring out evidence that helps your side of the case. Do you understand that?
Yes.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order. That's a summons or a subpoena, and that forces those people to come into court to testify on your behalf, even if they don't want to be here, which is the same way the state's witnesses are forced to come to testify against you. You understand that?
Yes.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. So no one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of this charge till proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at all. You may, but at trial, you may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes. Yes, sir.
Now, you originally entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all of the rights that I just described for you. Now, if you change your plea from not guilty to guilty, that's the opposite of not guilty plea. The guilty plea would admit the allegation in the indictment, admitted this crime, that you committed the crime. And that plea waives, gives up all rights I've described today except the right to have counsel. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you and to cross-examine them through your attorney, waives gives up your right to use the power of the court to compel or force witnesses to be in court to testify on your behalf, the same as the state. Waives gives up your privilege against self-incrimination because you're saying you're guilty, that's what's used to find you guilty. Waives gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court, and it waives or gives up any right to file an appeal you think you could have had up until this point in proceedings. Now, if I should ever sentence you to the maximum sentence, or under other limited circumstances, you could file an appeal, but that would have to be filed within 30 days for sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes.
Do you have any questions about the charge and the possible penalty?
No.
You understand them?
Yes, I do.
You understand the intervention in lieu of conviction conditions and what you're required to do in connection with your treatment program?
Yes, Your Honor, I do.
You understand the constitutional rights I've explained?
Yes.
You understand what the consequences of the guilty plea will be here if you enter it here today?
Yes, I do, Your Honor.
Is there anything you need to speak with Ms. Barger about before we go any further?
No, I do not.
You have any questions at all?
No, not at all.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of the intervention agreement that we've just gone through?
Yes, Your Honor.
Then as to the charge in the sole count of the indictment that alleges that on or about July 26, 2023 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit methylphenidate, in violation of Section 2925.11 of the revised code, 5th-degree felony, carrying a possible prison term between 6 to 12 months, fine of $2,500, a license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right. Court finds on this day in open court, defendant was advised of all of her constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. The plea is accepted and ordered filed. Defendant's found, or guilty plea is filed, but she is not found guilty. The case instead will be stayed. There'll be no entry of finding of guilty in the record at this time. Court finds that the defendant's been accepted, well, first of all, that her drug use and or mental health issues were factors leading to the offense, that she's been accepted in an appropriate certified treatment program, TRC. She's otherwise eligible for community control. She's not a repeat or dangerous offender, and is otherwise eligible under the law for this program. And so therefore, ordered that she be placed in the intervention in lieu of conviction program, that all criminal proceedings are stayed, that she be under supervision of the probation department for a period of 2 years under the terms for this program that have been previously approved by the court and filed. And those will, they'll give you a copy of those, go over those with you, Ms. Harrison, so that you know what they are. You'll also be required to successfully complete your intervention plan, and in particular, you must be free of using any drugs unless you have a legal prescription for them. You provide a copy of that, and alcohol for a period of at least 1 year. And you must then comply with the conditions as I indicated for this program, and you must pay the court costs of this proceeding. And if you do those things, then upon notice of that from the probation department, the court will dismiss the charge against you, even though you've entered a plea of guilty, and will set the matter for a sealing hearing. If the probation department feels that you are non-compliant, then they will file a written notice with the court. There will be a hearing at which you will be represented by an attorney, and in the event that the determination is that you have failed to comply, then at that time the court will revoke your community control. It could sentence you to a period of 6 to 12 months incarceration, fine you $2,500, and suspend your license for a period of 6 months to 5 years. All right, that completes the case. You're no longer under pretrial supervision or house arrest. You're under these new program, new conditions. So you'll need to stop seeing Mr. Arjima or whoever is going to be handling this, so they can arrange for your transfer over to the intervention program. Anything further, counsel?
Your Honor.
All right.
Your Honor.
Thank you.
Thank you, Your Honor.
All right, Mr. Kittrell. All right, this is case number 24 CR 44, State of Ohio versus Christian Isaiah Kittrell. Appearing on behalf of the state's Assistant Prosecutor King. Appearing on behalf of the defendant is Attorney Catherine Hapner. And you are Christian Isaiah Kittrell?
Yes, sir.
All right. The defendant has entered a plea of guilty to extortion, a third-degree felony. The matter was referred to the probation department for a pre-sentence report. I have received that, and each of the attorneys had an opportunity to review a summary.
State has, Your Honor.
I have it, Your Honor.
All right. Mr. King, anything on behalf of the state?
The state would ask that the court just follow the joint recommendation, Your Honor, place the defendant on community control, and also order restitution as outlined in the plea
Should back up. Has the victim of the offense been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, they have, Your Honor. Both victims have been notified and they've elected not to attend the hearing today.
All right. The restitution is $918.95 to Matthew Bliss and $540 to Eleanor Winker.
Yes, sir.
All right. And those numbers are stipulated, Ms. Hapner?
They are, Your Honor.
All right, Ms. Hapner?
Thank you, Your Honor. We would also ask that you follow the plea agreement. Christian has been at the Recovery Council of St. Lucy's for a couple months now. He was on April the 12th, he was given the award of the Client of the Week. He is, by all accounts, doing very well there. He spoke with his counselor as recently as yesterday and indicates that progress is good. There are no issues at all clean drug screens. There was an issue, I think, with marijuana when he arrived there, but that's obviously not an issue anymore, and doing very well. So we believe that community control would be appropriate. I'm not aware of any violations of his pretrial supervision, so I do believe he would be a good candidate for community control and ask that he be placed on community control.
All right, do you have anything you'd like to say?
I just wanted to express my remorse for the two victims, and I wanted to also thank you for ordering the drug assessment to be done, because this is the first time that I've ever taken my recovery seriously, and I don't think that I would have taken my recovery as serious if you had not.
All right. It is the judgment of the court that defendant be and is hereby sentenced to a term of 3 years of community control supervision under the probation department under the following conditions. First, you're to obey all laws of all jurisdictions and conduct yourself in a law-abiding manner at all times. You must report when and as directed and be truthful in all statements that you make to the probation department regarding your supervision. You must keep them informed of your residence and place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. And if you do, you must have a written pass showing that permission from your probation officer with you when you go into that other state. You're not permitted to enter upon the grounds of any correctional facility, nor may you communicate or attempt to communicate with anyone who is an inmate in any of those facilities without the written approval of your supervising officer. You're not permitted to purchase, possess, use, or have under your control any kind of a firearm, ammunition, dangerous ordnance, or weapons of any type. You may not purchase, possess, use, or have under your control any type of controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects that are similar to those, or any instrument, device, or thing that may be used to administer them or prepare them for administration, unless you have a lawful prescription for both the device or equipment as well as the substance. You must submit to drug testing when and as requested. You may not purchase, possess, use, or have under your control any kind of an alcoholic beverage, nor may you be present in places where they're sold or being consumed, even if that is otherwise lawful. You're not permitted to associate with anyone who has a criminal record, is a member of a gang or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless that's approved in writing by your supervising officer. And that also applies to any family members within that definition, unless you were living with them at the time of the commission of this offense. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type of relationship with another without written permission. You must report any contact with law enforcement, any arrest, citation, or conviction or any other charge violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by your supervising officer or the probation department for an assessment or any kind of treatment, therapy, counseling, programming, beyond that already ordered by the court, you're to submit to that. If the programming is recommended, you're to enroll in and successfully complete that. You're to pay the court cost of this action and make payment arrangements to do that. You'll make restitution to the victim witness escrow account in monthly payments, and I'm going to set that up at 50. Let's see, there's about $1,400. All right, $50 a month, beginning August 1st. And so that gives you a little time to get your personal life straightened out and hopefully get a license, get a job, and so forth. Well, do you have a license? Okay, if that's something you want to do. It'll help, you know, that's up to you. Now, you're also to successfully complete the residential treatment and aftercare at the counseling center. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, vehicles, residence, or any other property places under your control or where you're found at any time by any officer of the probation department, and you'll have to sign a written acknowledgement of that and consent to that waiver. The order is that you pay restitution in the amount of $918.95 to Matthew Bliss and $540 to Eleanor Winker. And that'll be payable through the victim escrow account, and you'll pay any fee charged for that. And they charge a $5 fee, so you'll make payments of $55. I think it's still $5, isn't it?
Yes, sir.
All right. Now, the court costs will also be ordered to be paid as a condition, as I explained. You'll need to make payment arrangements for that. If you don't pay those, it's also a substantive order of the court as part of your sentence. And if you don't make your payments or pay the court costs, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then they could refer it to collections, and if collections are required to collect it, the collection agency can charge you an additional 30% on top of what you owe. And if that doesn't collect it, then the court could order you to do community service in this county and give you credit for each hour you worked in an hourly rate set by the court, and each hour you work will reduce your judgment by that amount until paid in full. Now, Mr. Kittrell, if it's alleged by the probation department that you have failed to comply with these conditions, they will file a written notice of that with the court. You'll get a copy. There will be a hearing. You'll be entitled to have an attorney at that hearing. If the outcome of that hearing is that you have failed to comply, then at that time you could be sentenced to a prison term of between 9 and 36 months and fined $10,000. And if you are found to have violated the conditions by being convicted of an additional criminal offense and are sentenced to a prison term for that offense, that prison term could be required to be served consecutively to the sentence in this case. Now, if that occurs, upon completion of the prison term, the law provides that the adult parole authority could, at its option, put you under post-release control once you've completed the sentence for a period of up to 2 years. And if that happened and you violated those conditions, then they could return you to prison, even though you served the entire term set by the court, for an additional period of up to 9 months for a single violation. But there is a cap or limit of the 1/2 of the prison term for all violations. However, if you should be convicted of a new felony while under post-release control, then in addition to whatever sentence can be imposed in that new case by that judge could also sentence you for committing that offense while under post-release control. In this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, it has to be served consecutively to the sentence in a new case. All right. Is there anything further from counsel?
No.
All right. Well, that completes your case. You're no longer under pretrial supervision or house arrest. You're under these new conditions. You do have to report to probation immediately so they can arrange to have you transferred over to that program. So make sure you stop there on your way back to Portsmouth. Yeah, there's no reason, I mean, it's not in evidence in a court, so I don't really have any jurisdiction over it, but the prosecutor, if you notify them to release his phone to him. Yeah, I kind of make it a practice not to order the release of something I didn't order seized, unless it's in evidence of the custody of the court, so there's no reason for it not to be, but if that should not happen, then you can bring it back to the attention of the court. All right, this is case number 14 CR 82, State of Ohio versus Jeremy Boyd.